Yes, Mr. Villan.
Well, good afternoon, Lords. I'm afraid I haven't really made any progress on where the line should be drawn. We would say that our primary argument is that one looks at the mutual rights and obligations derived from the LLP agreement and any relevant agreements that might modify that, whether they're oral or what have you, as operated in practice. That's our primary case. Our secondary argument, slightly different, is that you look at the LLP agreement, etc. More strictly, but just
as a matter of interest, is there any impediment to oral variations of an LLP agreement? It's not like articles of association, is it?
Well, not in general. In this case, the LLP agreement provides that the board can amend the LLP agreement, but must do so in writing. For the note, that's clause 23 in the supplementary bundle, page 22. There's an entire agreement clause, clause 25.1, but we don't think there's a no informal variation clause. The difference being that get this right, the entire agreement is talking about what's happened so far, and the variation is what is talking about what might happen in the future. So I think we'd accept that it at least might be possible to have an informal variation that was accepted by conduct, provided you could prove what it was that was being varied with adequate specificity and clarity, and then demonstrate that all the members had understood and signed up to it, acted in accordance with it.
Yeah.
So as to give we're not saying that's impossible, but it hasn't been raised as what happened in this case.
I mean, that possibility, which certainly, speaking for myself, I have no quarrel with. I mean, that might work, might help to soften the edges somewhat of the other.
Certainly it would in a small partnership. If one thinks about a family partnership,
yes.
I think that maybe one of the examples actually covers this.
Think of a small farming partnership, for example, and I'm sure that can be varied by conduct in all sorts of ways.
Yes.
At least I can imagine it might be possible.
I think life would be impossible, in a sense, if a small partnership couldn't be varied. Or it might be very difficult if a small partnership couldn't be varied.
I suppose it probably wouldn't be an LLP in the first place, but well, at least it might be.
Well, if we look at 723 in the bundle, which is 2.5.1, example 29.
Yeah.
This is the revenues example. It's not, as it were, a real-life example, but Family Farm LLP has members, a couple, A and B, and their adult son, X. The LLP agreement has not been amended since before X was admitted. The way the LLP operates in practice is that A, B, and X all have a say in the running of the business, with A having a casting vote. And then the commentary is, although the written agreement was not amended when X was admitted, the implied terms of the agreement under which X was admitted was that he would have a significant say in the business. As a result.
Immediately obvious why a partnership of three anybody should have a casting vote.
That's fair comment. I suppose yes, if X doesn't want to be a cause of tension between his parents and doesn't vote, maybe that's why you need the casting vote. But subject to that point, the revenue would be happy with that sort of variation. I have to say I'm not quite sure how you can be admitted to an LLP without anything happening in writing, but maybe the point is that he's admitted, but the rules aren't properly updated to reflect what happens on the ground. So we'd certainly be happy with that, and I don't think that's a difficult proposition. I think what the court has difficulties with, and I do understand why, is whether, as one moves away from rights and obligations that are set out either in the LLP agreement, properly so called, or in any variations to it, to what extent that operates as a separate source of influence that can legitimately be taken.
Or, as you said earlier, a collateral agreement.
So absent a collateral agreement.
That might be an alternative to a variation. It's a collateral agreement.
Yes, sorry, I'm encompassing that as well. I agree, yes. So if one can point to some other agreement, whether that's set out in writing, whether it's a variation, whether it's a collateral agreement, whether it's a course of conduct that ratifies an implicit variation or collateral agreement. Now, I think one source of confusion, this is my fault, when we say that Mike Platt has significant influence, he's not a partner in this LLP. So, I mean, even if he has significant influence, it's not. He clearly doesn't have the right. He's not a member with significant influence, and that maybe using him as an example creates confusion because, as I say, he isn't a member. What we're looking at are members with significant influence, so they will necessarily be signatories to at least one LLP document in order to be admitted as a member.
But may it not be legitimate, even accepting all that, to take account of the existence of Mr. Platt and the overriding influence which he has in deciding whether any individual members of the LLP have significant influence?
Well,
maybe that they are so much subject to his overriding control that frankly none of them do.
No, agreed. And that was certainly one of our points below, and it remains one of our points, that there isn't really room for anyone to have significant influence, given how much influence he has.
Yes. And sort of tycoon syndrome, if you like. And it's a familiar sort of pattern, isn't it? Where you have the founder who's created an empire and then wants to carry on controlling it indirectly.
Well, in his case, this isn't someone who's holding on after he should have let go.
No, so I didn't mean to suggest that at all. Yeah, but in the abstract, one can imagine that type of situation.
Yes. Yeah. And the difficulty that one has is, as the revenue, you wouldn't. There will be some people who are trying to conceal. Sorry, maybe that's too pejorative a way of putting it. Some people who wouldn't want their involvement to appear on the face of the documents, but who would nonetheless want to enjoy influence, not necessarily for any reason connected with the LLP salaried members rules, but there are all sorts of reasons why people don't necessarily want the extent of their influence to be obvious to those who are looking at public documents like the LLP agreement. So, the easy position for the revenue is to say, just look at the agreement subject to variations, collateral agreements, etc., etc. I accept that in a sense is the easy position for us. I've described that as our secondary position. Our primary position being that one can look a little bit broader at how things are done in practice, even if it's not absolutely in accordance with the terms of those documents. But maybe I'm just making life harder for us than it needs to be.
Well, you're making it hard for us in a sense. How is it we can square that with the statutory language?
Well, the reason our primary submission is that it doesn't need to be decided for the purposes of this case, because first, we're also interested in the type of influence, not just the source of the influence, but the type of influence. And as my own friend has said, when looking at the type of involvement in management that a typical partner would have, we would say that is the sort of involvement and the sort of influence that one would expect these rules to be interested in. And that is the source of influence that properly draws a line between quasi-partners and quasi-employees. And the members that we're talking about here don't enjoy the right type of influence. So regardless of where the influence might come from, it's the wrong type of influence. And or, we would say, it's not significant because it's too dilute, which is the other main point on influence.
What is the right type of influence?
Sorry?
What is the right type of influence?
Well, the right type of influence is the high level, as it were, board level influence over the affairs of the partnership generally. That doesn't mean that you've got to have a casting vote in relation to each and every aspect of that level of control. but one would expect to see general participation in and influence over the sort of decisions that would be taken at the highest level in the partnership. Extrapolating from, you know, a small partnership who might have a management board of 10, or 5 to 10, who would be dealing with the big decisions.
And if those decisions are influenced by a member who is not a board member, would that be the right kind of influence?
Well, then we come on to the, yes, it could be. Then it's the
Suppose
right type
that one of the portfolio managers has discovered a most fantastic new market with huge growth potential, and the board decide, well, we must reorientate our strategy towards that market because this chap has done so well.
Oh,
is that the right kind of influence?
No, because that's the board is doing the influencing. The member has had an effect because they're responding to something that the member has discovered, but it's not the member isn't directing the board in accordance with his or her will. The member has just been carrying out their function as a portfolio manager, has uncovered, as you say, a terrific new product, or I think we've got examples of people needing to move quite quickly to move into crypto or move into Russia and Ukraine, or perhaps out, and that sort of thing, where an individual's insight might have a significant effect, but we would say merely having an effect. It isn't the same as wielding influence as this needs to be construed. Anyone, frankly, could have an effect on what the LLP does. Whether that's a good or a bad effect. It could be a portfolio manager, as your lordship says, uncovering or creating maybe a new income stream, a new business stream, a new type of product, or at the other end, someone making a horrific mistake that takes down the IT system for a week so that the partnership can't do anything. I mean, that would have an effect on the affairs of the partnership in one sense, very much for the worse, but no one, I think, would say that the IT person responsible for that mistake was exercising significant influence over the affairs of the partnership within condition B. So I think we would say one needs to distinguish between active, deliberate influence, i.e. directing or contributing to the direction of the partnership deliberately, and having an effect on the business of the partnership by virtue of good or bad performance in one's role. I was going to, if I may, just going back to the skeleton, going back to our skeleton, except I've taken it slightly out of sequence just to deal with the point about the source of the obligations. But to be sure I cover all the points. This influence starts on page 12, internal page 4, bundle page 34 of our skeleton, paragraph 41. I think your lordships have the point that influence is to be construed in light of the type of influence one would expect from a traditional partner. Expect a traditional partner to have over the affairs of the partnership above and beyond that of an employee. So it's influence over the management of the affairs, as opposed to financial or operational contribution. And we've said there, this is the point I was making about effect or impact. Impact and contribution are not themselves influence. We say that the type of influence that partners enjoy is influence, meaning participating in the business decisions and shaping the business, not merely the opportunity to do very well or very badly in a designated function. And And then we're on to the partnership cases, which we've already covered.
Sorry, just before I forget, in the case of individual portfolio managers,
Yes.
we all have a vague sense of what it is that they do. Is there any written description or written terms and conditions that they have to comply with? I mean, if so, I haven't come across any record of that anywhere. I don't think.
There probably is. I mean, maybe I could come back and...
Yes, it may not matter. It's just, given the focus on the written partnership agreement, I just want to be clear that there isn't any other important written document setting out.
There will be. I mean, we had discussions around, I mean, to be fair, it mainly focused on their remuneration rather than the designation of responsibility.
And I do remember reading somewhere they were subject to various constraints at the time you might accept, which they must be probably formalised somewhere.
It is somewhere. Whether it's made it into the Court of Appeal bundle, I'm afraid I'm less certain. But in broad terms, they would each have an area in respect to which they're entitled to take positions, in broad terms invest, and their capital allocation reflected how large a position, how big a risk they could take. If they went outside those parameters, they would be scrutinised. If they made losses, there's a stop at a certain point. If they made a loss of 5%, and their positions would probably be handed over to someone else. So they were tightly constrained. And obviously they also had to behave appropriately in other ways. They would have been subject to FCA regulation. They'd have to comply with HR policies in the way that every employee...
And there must be provisions, I imagine, about working time and leave and devoting their whole time and so on to the business.
Yes, all the normal sorts of...
you might expect.
Yes, but those sorts of things one would expect of a member of a large partnership as much as of an employee.
Indeed.
No one's saying that those sorts of provisions that tell one from the other. But yes, they are. It's certainly true that they're free within constraints to run their own portfolio, and whether you view those constraints as I think setting the constraints, setting the restrictions, setting the parameters. That's one of the higher level functions. And I think BlueCrest would say that it's because, as a group, BlueCrest was very good at that. That is what contributed to its success. That sufficient restrictions to stop people losing money, whilst allowing sufficient freedom to let them make money.
Yes,
it's for BlueCrest to blow their own trumpet on that, but I think that is the gist of what was said below.
Well, and the need to recruit the very highest quality managers was a recurring theme in the last BlueCrest case.
No. I mean, that's mentioned here.
Yes, it is mentioned. Yes,
in two ways. Obviously, the senior portfolio managers, when they're brought in, will want eventually at least large capital allocations, so that they've got an opportunity to make profits for the firm. Because the more profit they make for the firm, the more money they're given, generally. And outside the portfolio managers, the evidence on the allocations is certainly that the market for a given role was one of the factors that was taken into account in setting someone's discretionary limits. So I haven't got the detail at my fingertip, but there's an example given, I think, of an IT person who was very good at his job, but in circumstances where the general market for that job was falling away. So it might have been harder for that person to move to a higher paying job somewhere else. I don't want to risk making up facts, and maybe I'll pull out that reference in due course, but the outside market is, and how generous a bonus BlueCrest is able to give is certainly a factor in its success.
Thank you.
If we come back, if we find the terms or the employee handbook or a reference to it, then we can provide that. Now, we discussed, or my learned friend discussed, the relevance of subordination as a way of distinguishing between partnership and a partner and a worker in Bates van Winkelhoff, we're obviously not saying that condition B can be construed simply as asking whether this is a relationship of subordination. Two reasons for that. One is that's not what the words say, which your lordships might think was a sufficient reason. But also, the approach of the three conditions, as I already said, is between them to encapsulate three aspects of the partnership relationship. This can't be, one can't substitute that tripartite approach with a single touchstone approach, or with a general approach asking, does this person look like a partner or look like an employee? One has to apply the words separately. But we say points like subordination do feed into how one construes influence, subordination in particular. That one would expect someone with influence not to be subordinate, but to be contributing to the giving of directions. Sorry, maybe I'll give you the reference now. No, I think I'll come back if I can find a pithy reference. So what we're doing, we say, with all the conditions, and particularly with condition B, is trying to separate employees from partners, employees from quasi-employees from quasi-partners, by looking at influence in the sense of deliberately directing the partnership in accordance with your will, rather than, and this is paragraph 47, having an impact or making a contribution to the business. So, it's really just what we said in the skeleton. Picking it up at the third sentence, if we're looking at impact, there'd be lots of people who would have a significant financial impact with a limited influence. We said a salesperson might have a significant financial impact if particularly successful or unsuccessful in selling a product. And this is perhaps your lordship's example, but without having any direct influence on the company's business strategy at all. So this is someone who might actually be an employee in charge of selling whatever the product is, and is particularly good at that job. Now, that obviously has an effect on, an impact on the company's business, possibly its bottom line, possibly in response to that they change their strategy. And you know, if this is a salesperson who's operating in a certain market, maybe they redirect their resources towards that market. But that is not, we would say, the sort of influence that a partner has. That's the sort of influence that, that's a factor that the management would take into account in wielding influence. It's the wrong level of effect.
How far away from the written agreement do you get? This is where I'm not quite sure that I've grasped exactly where HMRC are. Postulate a 5-person LLP where everybody attends the meetings of the board. Everything is decided by a majority vote, and one of the members is always in the minority. Does he have significant influence?
Well, I think we would accept that that person has significant influence because it's about well, rights and duties. It's at the it is certainly about rights and duties, and therefore potential effect, rather than necessarily only about actual effect. We're certainly not going as far as saying it's only about actual effect. One would ignore sham or mislabeled obligations and rights or duties, of course. Now, the fact that this one of 5 partners is always outvoted, we would say doesn't rob that person of, in itself, rob that person of influence. Now, maybe, and I don't need to be committed to this, but maybe if you change the facts a little bit and you found that the other 4 had a collateral agreement that effectively excluded that person from the decision-making process, then yes, maybe then that person wouldn't have influence. If they always said, well, we'll meet before and decide how to vote, and we'll just make sure that Mr. 5 or Mrs. 5 doesn't get a proper say in it. I mean,
perhaps this can also tie in with the focus on rights and duties, can't it? Because the focus of that language seems to be very much on the structure that is set up, rather than with how it works in any given case. So you could have a structure whereby, in my Lord's example, the one member who's always outvoted is a member on the same theoretical basis as everybody else. It just happens he takes a different view on things and has perhaps a different philosophy, which is reflected in the fact that he always ends up on the losing side. But that doesn't prevent him having influence in the sense which is necessary.
But yes, it doesn't prevent that partner having the appropriate rights and obligations, so as to be able to
I mean, in a traditional partnership of 5, one partner could always be outvoted.
Yes, absolutely. And as I say, unless we're talking about secret agreements in the back, that is obviously the starting point. We'd accept that person had significant influence.
That ties you to the formal structure.
Well, as I said, it would be easier for me to accept the formal structure argument. I quite see that. Our attempt to accept actual influence outside that is perhaps an overzealous attempt to take a realistic approach, etc., in line with the authorities. But yes, the idea of focusing on the structure that gives the influence does also help explain what type of influence I think one would be looking for. It's the right to take part in the relevant decisions as much as the effect of taking part in the relevant decision. I was back in the skeleton to source of influence, and as I say, on any view, the starting point is the LLP agreement. We're not disagreeing about that. The question is just whether that has any penumbra of de facto influence. As I say, we would accept that it does, but it doesn't hurt us in this case to say one only has to look at the rights and obligations under the LLP agreement. There's no suggestion that there's a variation that we haven't seen. So the evidence was that even where there were informal decisions taken, they were then ratified by the formal process. So the members were keen to say that they adhered ultimately to the formal structure. So we're not relying on people acting outside that. If anything, it would be BlueCrest relying on that. So in this case, we'd be happy with the outcome. But your lordships will appreciate that the revenue's wider concern, beyond this case, is to promote an approach to the construction of these conditions which work for taxpayers and the revenue alike in a practical and real world, which is perhaps why there's some softening in the guidance. And if necessary, the lordships could say, we think the law is X, although we know that the revenue has adopted a concessionary approach in the guidance, or say the revenue's guidance is therefore a concession.
Well, you don't want somebody drafting an LP agreement which looks hunky-dory but doesn't actually get put into practice.
No. And that would face possibly several difficulties, make life a lot harder for everyone. So as I say, what the revenue was trying to promote, and it's set out in the in the guidance on condition B starts by saying, in fact, all the conditions started by saying that it should be a common sense approach. No one wants this to be an overly legalistic approach. I appreciate that's an ironic thing to be saying after in the third round of appeals, but in the normal course of things, everyone would benefit from having clarity as to which side of the line the partnership falls on, and not getting too caught up in what might sometimes be called theological debates about the source of the rights and duties. Now, that's not, obviously, that doesn't mean we can't get it, doesn't mean that we get away from the words. I absolutely agree. We start with the words, we start with the LLP agreement. It's just whether there is that penumbra or whatever one wants to call it.
Okay, just to be clear on one point, I don't think you're submitting, are you, that one could somehow read down or construe the words rights and duties as having a wider connotation in this context, and prima facie there's legal meaning?
No. I say we're if someone had influence outside the LLP agreement, it would have to be the sort of influence that people treated as if it were a right.
Yeah, that's a slightly separate point, and I think we were saying earlier, it's certainly relevant to take into account the position of someone like Mr. Platt.
Oh, I see. No.
Because that might impinge on the reality and extent of any influence which is in fact wielded by the partners themselves.
I meant a slightly different situation where if you had partners who were on paper equal, but in fact the others tended to defer to completely as routine and as if that person had been given superior rights under the agreement. Now, that might not be backed up by a variation or ancillary or collateral agreement or variation. That might be something that just happened. It might be that maybe the capital rights are unequal, but the voting rights are equal, and people tended to defer to the person with the capital rights, not actually in accordance with the LLP agreement, but that is how everyone approached it. In that sort of case, we would say you would have moved away from the strict terms of the LLP agreement, but when asking whether that person had significant influence, we would say certainly the guidance would mean that you could look at that person's de facto additional influence and weight in discussions. Now, if we're talking about 5, it might still be that all 5 still had significant influence. But if you expand that to a partnership of 50 or 100, and you have one person who has a vastly disproportionate influence, and that influence is, although not derived from the LLP agreement, universally recognised by the others, we would say that, at least on one version of our argument, would be something that could be taken into account. I'm going to repeat, that isn't something that we're saying happens in this case, and we don't need to establish it in this case. That's separate from the Mr. Platt point, which is that he has such a level of control that there's no room for anyone else to have significant influence, or not for most people to have significant influence. That's a separate point. I'm not sure that there's too much more I need to say about what the words mean on influence. I did want to pick up 2 more points. One is find, mind, and grind, and one is affairs of the partnership. Find, mind, and grind, as your lordships will have seen from the FTT decision,
yes, Judge Popplewell was effectively saying what partners and solicitors firms do.
Yes, and his argument seemed to be, well, what partners do is find, mind, and grind. Therefore, if I decide, looking at it, the portfolio managers seem to be finding, minding, and grinding. Therefore, what they're doing is a bit like what partners do. Therefore, now we say that the problem with that is that it focuses on the wrong thing. Not denying that that is a way of looking at what partners do. Whether it rhymes or not, it might be a good description. That's beside the point. But asking what partners do isn't the same as asking what influence they have, we would say. So that's where it's gone wrong. He's just been asking the wrong question. Now, the Upper Tribunal says that we, in effect, that we were misrepresenting what the relevance the tribunal judge had attached to finding, minding, and grinding, and that it was open to the court. It was open to the FTT to look at what they did, to look at the role they played within the partnership, but that the FTT hadn't, in fact, been finding it, hadn't been using it as a test as such. He'd only be using it as context. This is paragraph 56 of our skeleton. So we say that the first point is significant influence about what people do? We say it isn't. You can't answer that question by asking what people do in their daily role, their daily job. One way of, we say, realising that is that there would be no impediment at all to having an employee whose job was to find, mind, and grind. It just doesn't help differentiate. What we're interested in is not what they do, but in the relationship they have with the LLP and the other partners. And the finding, minding, and grinding stuff doesn't tell you anything about their relationship with other partners. Sorry, that's a slight exaggeration. The minding tells you something about their relationship with juniors, people below them in the structure chart, as it were, but it doesn't tell you anything about their relationship with other LLP members or other partners in the partnership.
Well, the very definition of traditional partnership is the relation between persons carrying on business in common with a view to profit.
Yes, well, that's the fundamental, exactly. But the finding, minding, and grinding is the day-to-day operation of the business. It's not the managerial supervision of the business. That's our first point. I mean, the other way of looking at it is 59. A senior associate in a traditional law firm will, no doubt, be doing all those things. They will be finding work, undertaking business development and building relationships with clients. They'll be supervising trainees or junior associates, and they'll be undertaking client work themselves. And they will, by demonstrating their excellence in those areas, they will hopefully make a strong case for promotion to the partnership properly. The senior associate is clearly an employee. So the point here is that it's just not a good test for differentiating between those two categories. We also say that although finding, minding, and grinding might be a good description of a partner in a professional services firm or a law firm in particular, it doesn't actually tell you very much about what a partner does in general. And I think this is your Lordship's point, that all that a partnership is people carrying on business in common with a view to profit. There's an infinite range of partnership businesses. We've given the example of farming partnerships. You might have GP practices, rock bands, building firms, which make it hard to make generalizations about what people do on a day-to-day basis, because different partnerships will do different things. The point there is that you might have, in a farming partnership, you might have a senior generation who retain the capital rights, but whose involvement is more about supervision and teaching. And you might have the next generation who are getting their hands and wellies dirty. They're carrying out different roles. You might have the GP practice, the rock bands, the building firms. In all these cases, you might have different partners doing different things, but all contributing to the common business. But what they've got in common, if they're actually partners, is their participation in the management. So you're looking at the wrong thing if you're looking at the day-to-day activities. And I mean, that's even for professional services firms, that's going to be true. So you might have a managing partner who doesn't do very much, might not do very much finding, minding, or grinding because they might be so busy doing admin. So I appreciate that one counterexample doesn't destroy the finding, minding, and grinding, but it does illustrate that it's not a universal truth. C, the third point was whether this finding, minding, and grinding is helpful. And we say, actually, finding, minding, and grinding isn't even helpful for the reasons we've just given, really. That it's looking at the wrong sort of thing. It's looking at daily activities. And it's focusing on one type of partnership in a way that can't be usefully extrapolated to general partnerships, to the generality of partnerships, which means that it doesn't provide a useful guide or touchstone for the application of the test at all. Put it another way, you can have people who are obviously partners who don't do any finding, minding, or grinding, or anything analogous to finding, minding, and grinding. And so it's just not helpful. So you pick this up at 62. The judge, this means the FTT judge, described the necessary qualities of a partner, in his experience, as not limited to making management decisions, but to contributing to the success of the partnership. By undertaking client work and supervising teams of individuals who undertake that work, the partner is able to bill the client and thus contribute to the ongoing commercial activities of the partnership. Once again, the FTT's approach here fails to recognise that these contributions to the success of the partnership are equally true of senior employees. So this description does not identify factors which assist in distinguishing between senior employees and partners. So we say finding, minding, and grinding not helpful, indeed an irrelevant distraction. It's not that finding, minding, and grinding is possibly a wholly freestanding ground of appeal, but we would say it's, if nothing else, a good illustration of the problems with adopting the wrong construction of what is meant by influence over the affairs of the partnership. Which brings me to the final limb of it. Again, not asking that affairs of the partnership should be atomised and looked at wholly in isolation from the rest of it, but there is a question about what is meant by the affairs of the partnership. In particular, whether it's talking about the affairs generally as a high level, or whether it's enough to have day-to-day influence over an aspect of the affairs of the partnership. Now, we say, the revenue says, that the words require consideration of the partnership, of the affairs of the partnership generally. It's not reading in, that's just what the word says, the affairs of the partnership. It doesn't mean that every partner has to exercise control over every decision at every opportunity. It is a general test. But it does mean that a person or an LLP member whose influence is limited to one discrete category of partnership activity or one type of decision, for example, an HR, something that's just limited to HR, wouldn't be exercising influence over the affairs of the partnership, we would say. So someone who merely participated in hiring and firing decisions and no other high-level decisions would not, we would say, be exercising influence over the affairs of the partnership, as that expression should be understood in the context of condition B. The Upper Tribunal rejected that, saying that it involved reading in additional words, and that it would be capable of producing strange results. That's in the Upper Tribunal decision at 91 to 92. And we say that's wrong. First, we say it doesn't involve reading in. I think I've already said that, really. the affairs of the partnership, we say, is capable of covering the affairs of the partnership generally. Indeed, the counter, we would say, involves, if anything, involves reading in. If what is to be understood is any aspect of the affairs of the partnership, that is what needs to be added to the expression. Whether your lordships come that far with me or not, I would say it's at least arguable either way that additional words are required, and it's not a factor that can tell in for or against HMRC. Primary argument is that it's the affairs of the partnership is naturally read as referring to the affairs of the partnership generally. And my own friend Mr. Kirby's submissions on how the partnership law operates, we would say, reinforces that. That the type of decision that one would expect a partner to have involvement in as a matter of partnership law are the ones affecting the affairs of the partnership generally, rather than a discrete subset of decisions. We say that also aligns with the wider words of Condition B. The legislation looks at the mutual rights and duties of the partners, reflecting that we're interested in the relationship between partners rather than individual areas of responsibility. So we're looking at, as I say, mutual rights, but also common rights. We're looking at what all the partners do.
Are the concepts mutually exclusive?
The concepts
You're in charge of something particularly important, say IT system.
Oh, no.
That, whatever you decide there, could have a knock-on effect on the affairs of the partnership generally.
Absolutely, it can have an effect. And it's going to be a matter of degree, obviously. But we would say that someone who only has responsibility for IT does not have influence over the affairs of the partnership generally. Or indeed, over the affairs of the partnership, full stop. What they've got is responsibility for an aspect of the partnership's business. But that's not the sort of influence or responsibility that is the touchstone of a partner. Whether that's IT or HR or any other discrete function, tax, legal. So we would say no. Now, that isn't to say that, I mean, you could have a partner in charge of IT who is also involved in the general votes. I mean, so they're not mutually exclusive in that sense. But the fact that you're looking at the mutual rights and obligations, we say, is at least a pointer that what you're looking for is something that engages those reciprocal rights at the highest level. So it's going to be the same for all the partners. That's the starting point. Now we say that is the point I've just made, really. This aligns with the position of partners in a traditional partnership, that they are together running the business. Different people will do different things on the ground. I'm not sure whether you put this example in here, but you know, the original, a very original form of partnership and indeed company would have been merchant venturers. Someone might own the ship, someone will captain the ship, someone will put up the money for the cargo. They might be partners. They've all contributed to the partnership in a different way, but they are all partners. And then the decision they'll make together is where to go, what to buy, and so on and so forth. They're all contributing in different ways to the partnership. I've already said that in relation to the different types of we say the Upper Tribunal is wrong to consider, this is paragraphs 91 to 92 I've already referred to, wrong to consider it would be highly unrealistic to look at the affairs of the partnership generally, and that such an approach would be capable of producing strange results. Now, the basis for that comment was that, say, for small partnerships, one would expect the members of a partnership to have individual areas of responsibility within the business. We say, well, that might be right. It focuses incorrectly on the individual's role within the operation of the business, rather than on the individual's influence over the business as a whole, over the managerial and strategic decisions of the partnership. When one focuses on those high-level decisions, It's not right to say that one would expect almost every partner in a partnership of any size to meet condition B. We would say a partner in a law firm who's responsible for the tax department might have significant influence, not through that responsibility, but through general voting rights or participation in the management or strategy committee. It doesn't follow from the fact that a large partnership might have a departmental structure. It doesn't follow from that one would expect the heads of those departments to have significant influence. I mean, that's part of a wider point that certainly in our skeleton, I probably haven't dwelt on it, there should be no presumption that in a large partnership, all, or frankly any of the partners have significant influence. It doesn't need that. Many of the partners will, if they are quasi-partners rather than quasi-employees, will get home, as it were, on the capital contribution or on the condition A remuneration limb. So it's not it's not a well-founded argument from absurdity to conclude that in a large partnership you might have no one with significant influence. And this is the point in 71 of our skeleton. In fact, we would say the stranger result, if anything, is the conclusion that 82, or depending on how many of the more junior partners who exclude from that, 50 to 82 of the members of the LLP all enjoy significant influence. We would say, in fact, by the time you've got 50 people influencing something, it's unlikely that any one member's influence is significant. So if strangeness tells in any direction, we would say in the revenue's favour.
And in fact, with a partnership of that size, I imagine you'd be more than likely to have some kind of managing committee or something, in which case they might be the more natural targets to where to look to find significant influence.
Precisely, which is what we find here with the original
Indeed.
EXCO.
Yep.
And normally there would be a managing committee. One would think you couldn't sensibly manage something with a committee of 50 or 80 people. I mean, I suppose that's giving evidence, but there are limits to the size of committee that can sensibly make decisions. So it's not surprising, we say, to reach the conclusion that only a limited number of people can have significant influence, and that it's not the fact that our construction leads to that conclusion doesn't mean that there's the wrong construction.
And waiting in the wings, so to speak, is your other point, that in order to be taxed as an employee, all three conditions must be met.
Yes.
And so even if you don't have significant influence because you're in a partnership of 100, if you're paid as a share of the partnership profits, then you satisfy condition A.
Absolutely, and that's the paragraph 71 point. So even if you only have 1% of the profits of the firm, or 0.1%, that's enough. There isn't if you're wholly paid by reference to firm profits, then you would clearly fail to meet condition A. You would escape condition A, and therefore you would be taxed as a partner. And there's also condition C, which we're not looking at, and it has its own difficulties.
That would help sleeping partners, so to speak, who put up some money.
Yes.
That don't actually play any active part in the business.
I think it could, but the calculation for condition C is something that we probably don't want to go into for all sorts of reasons just now. But yes, you've got pay, you've got influence, and you've got capital, and you only need to escape one of those conditions in order to be taxed as a member.
So in your merchant venturers example, the chap who put up the money for the cargo escapes.
Hopefully. Exactly. Although, in my example, that person also had influence because they were involved in a discussion of whether to go east or west or whatever it might have been. So we say on condition B that the the Upper Tribunal, or the FTT, and then followed by the Upper Tribunal, made errors of construction in relation to condition B. That properly construed, what one has to do for condition B is consider whether the member has influence over the affairs of the LLP generally, looking at the business of the LLP as a whole, and yes, derived from the mutual obligations, rights and obligations, rights and responsibilities under the LLP agreement, etc., with the possibility of a penumbra outside that. And we say in line with the joint venture nature of a partnership, and as I've said, the rights and duties of traditional partners, influence can be described as managerial or strategic influence over the affairs of the partnership generally. And then, as to significance, it must be significant in the context of that business. And there will be a level below which someone has influence, but it's not significant or sufficiently significant. Now, if we've got that far, there are questions about disposal. Shall I do those very briefly? I think I can do it in 5 minutes. So, if we're right on that, and if my own friends, if we're also right on condition A, we would say, sorry, if we're right on this is clearly, we would say, an error of law that might, or indeed would, have made a difference to the decision. So we say that means the decision of the Upper Tribunal has to be set aside, and then the court has to decide, this court has to decide whether to remit, in this case it would be to the FTT, or remake the decision. Just for the note we've got in the skeleton, the question of whether to remit is whether it's in the interest of justice to remake the decision or remit it. It's an active. That's the Upper Tribunal, but I think it's a proper statement of the law. We say one thing that one caveat in paragraph 74 of our skeleton: where a party has failed to plead its case or produce evidence to support the case, it may not be in the interest of justice to allow the party to have another go. That's the Court of Appeal in Tooth. Appreciate the Court of Appeal that went to the Supreme Court, but I think just taking that point from the Court of Appeal, paragraph 68 in Tooth. So it wouldn't be, we would say here, appropriate to remit this case to the FTT so that BlueCrest could adduce evidence that it didn't adduce first time round. Now, of those options, remake or remit, we say it would be open to this court to remake the decision quite straightforwardly. On the basis that none of the members had significant influence properly construed within condition B. The point was raised by BlueCrest that they had such influence, but there's no express finding to that effect. And if the FTT had thought they had such influence, it would have been a very easy answer to the Revenue's case, just to say it doesn't really matter which of you is right on what's meant by significant influence, because the portfolio managers and desk heads had it in any event. If everything else is undisturbed, then the Revenue wins on all aspects of the appeal. That's set out in the skeleton at 75. Now, in fairness to the Upper Tribunal and the FTT, it's right to point out, this is the Upper Tribunal at 111 and 123, I think just for the note at this stage, but I may need to come back to it. The Upper Tribunal suggests that the FTT did make a finding that the portfolio managers and desk heads had significant influence at FTT 194. I don't want to go through this in detail, but we would say that the 194 is much more complicated than a simple finding. At first, it's really not clear what the, I haven't set it out in the skeleton, it's really not clear what the tribunal means by managerial clout, which is the phrase he uses in that paragraph, we say he seems to be referring to one of two things. Either he's looking at informal management but at a lower level than our strategic management. Again, for the note, you get that from FTT 187 and 108. Or possibly he's referring to what he calls local management. That's in FTT 175. So we would say the Upper Tribunal was wrong to say that the FTT made a finding that the portfolio managers and desk head had significant influence of the sort the revenue says is required. But it does require quite a close reading of the FTT's decision, which I don't want to go through in detail now to disentangle that. So it is right to approach it as it were, a higher level. Overall, you can see the FTT is clearly saying that influence is a wide concept, and he decided the case on that basis and did not make the express finding that they had influence of the sort that we say would have been required. So one simple option, we say, would be for this court simply to remake the decision in our favour. Another simple option, and this I think is BlueCrest's preference if we succeed on condition B, is to remit the appeal to the FTT, same judge, to remake the findings of fact and the determinations in light of this court's direction on the proper meaning and construction of condition B. The only wrinkle there is that we say that reconsideration should be limited to 100 million plus portfolio managers and desk heads and should not include the others, and certainly shouldn't include the sub 100 million portfolio managers. So that remitter is the second simple option for the court. The third option, which I appreciate is definitely a less simple option, is for this court to delve into the detail a little bit more along the lines set out in paragraph 76 and following of our skeleton. However, unless the Lordships particularly want me to do that at this stage, I was proposing not to, and to say that is our case.
Yes. Can I just ask you about paragraph 80 of your skeleton? Where you raise an Edwards and Bairstow challenge. Is that one of your grounds of appeal?
Well, in effect, yes, because it's about the application of condition B.
Well, what you say in your... Oh, I see.
Oops.
You say it's within ground 14 or 15, do you?
I hope so.
"14 says that the decision can and should be remade. 15 says it can remit. We can remit to the FTT to address certain findings of fact. But I don't think that's a challenge to the findings of fact as such on Edwards and Bairstow lines, is it?
Sorry.
When you say it's contrary to the evidence given by BlueCrest's own witnesses, that's not to do with construing the statute. That seems to me, at any rate, to be an assertion of irrationality, which isn't one of your grounds.
Sorry. Well. AC in particular.
What you say in 80
Well-
is if the FTT was concluding that each portfolio manager had significant managerial influence
Yes.
over the LLP in general, that conclusion is inconsistent with the evidence given by the LLP's own witnesses.
Yes.
Isn't that an irrationality challenge?
Well, that's, sorry, maybe I'm looking at the wrong thing. That's 13B2 of the
B2.
grounds.
Oh, I see. Yeah, all right.
So we, I mean,
So that's there in the ground.
I mean, the wording is the same. We haven't
Yeah.
referred, I think, to Edwards and Bairstow in terms there, but we were just trying to mirror it.
Thank you.
Okay.
My Lords, in these submissions, I propose to deal first with HMRC's appeal on Condition B of the salaried members' rules.
Yep.
And as you've heard from my learned friend, HMRC have submitted that two categories of partners, the PM members as we have designated them, and the desk heads, should have been held by the FTT and the Upper Tribunal to meet Condition B. And the appellant's position is that the members do not meet Condition B. Having responded to HMRC's appeal on Condition B, I'll then deal with the BlueCrest's cross-appeal on Condition B, which concerns, as my learned friend has mentioned, the categories of partner who are held by the FTT and the Upper Tribunal on the facts to meet Condition B. And our position on that is set out in our supplemental skeleton. Very briefly, our position is that BlueCrest's cross-appeal is necessary only if you agree with HMRC that the tribunals misconstrued the statutes, in which case we say it will be in the interests of justice to apply your preferred construction to all categories of member and not just to the PM members and the desk heads, is that it will be appropriate, as my learned friend has trailed, to remit the case to the First Tier Tribunal if you uphold HMRC's construction appeal for the appropriate findings of fact to be made. And then finally, I will deal with Condition A. BlueCrest's position, very briefly, is that the FTT and the Upper Tribunal misconstrued Condition A, and on its true construction, the findings of fact already made by the FTT must lead to the conclusion that the PM members and the desk heads didn't meet Condition A. My learned friend, Miss Poots, suggested that we were appealing the facts as well as the law, and as I will come on to explain, that is not the case. Starting then with our response to HMRC's appeal on Condition B, my submissions are going to fall into 6 parts, and will briefly and broadly follow BlueCrest's skeleton argument, which is at the core bundle, divide 5, page 57. But I thought it might be helpful if I give you a brief roadmap of how I'm going to structure those submissions. Firstly, I'll give you some brief background and set out what we say needs to be understood regarding the affairs of the LLP in order to be able to construe the operation of Condition B of the salaried members' rules in context. Secondly, I'm going to summarise the principles of construction which we say apply, and look briefly at the recent case law on the correct approach to statutory construction. Thirdly, I'm going to make some submissions on the background to the salaried members' rules and why we say that it's relevant to understanding their application to the facts of this case. And I'll also show you some of the technical notes which my learned friend Mr. Flatt took you to part of. Fourthly, I'm going to deal with HMRC's grounds of appeal and why the appellant submits that they should not succeed. Fifthly, I will look at the statute in more detail and apply it to the facts to demonstrate why the approach of the First Tier and Upper Tribunal did not contain in our submission an error of law. And finally, I'll deal with the correct approach to the FTT's findings of fact and the question, as my learned friend has trailed, whether it would be appropriate to remit the case to the FTT should you find for HMRC. As my learned friend has indicated, the respondent is a UK registered and resident LLP, And it's just important, I think, to bear in mind that the respondent has two roles in the BlueCrest group. First, it acts as a sub-investment manager, so that the LLP's partners are principally involved on a daily basis in making investment decisions in respect of a portion of BlueCrest's total assets under management. And secondly, the LLP provides support services to the wider group entities. So the LLP has those two roles in the BlueCrest group, which constitutes its business, or indeed its affairs. The dual business element is reflected in the LLP agreement itself at clause 4, and I will return to this. But in summary, we say that in the case of this LLP, governed by this LLP agreement, the centrality of the portfolio managers and the desk heads to the business is a relevant factor in applying condition B. BlueCrest has always submitted that understanding the scope of the LLP's business is essential to applying the relevant tax law to it. As I will develop, that's especially the case in respect of condition B of the rules. As you've heard from my learned friend, the salaried members' rules are targeted anti-avoidance provisions introduced in 2014. And they were introduced to remove the presumption of self-employment for some members of LLPs, and so tackle the disguising of employment relationships through LLPs. And that explanation of the purpose of the legislation closely mirrors the wording in the consultation documents. I do not need to take you to them, as my learned friend has already drawn them to your attention, but for your note, the authorities bundle references on the purpose of the legislation, a paragraph 1.2 of the consultation document. That starts at the authorities bundle, tab 41, page 625.
Do you want us to turn it up now?
I'm very happy if you would like to turn it up, my lord.
One 1.2.
1.2, yes, 665. Page should be 665 of the bundle. So you'll see.
So this is in the summary of responses, to be accurate.
No, this is the original consultation.
This is the original consultation document, the first document.
I thought you said 665?
Sorry, 625.
Oh, 625.
Sorry.
The paragraph you want is 629, I think, isn't it? You said paragraph 1.2.
Paragraph 1.2 at page 629. Apologies, my lord. We will come on to the response to the consultation document. But at 1.2, at budget 2013, the government announced that HMRC will consult on two aspects of the partnership rules: removing the presumption of self-employment for some LLP members to tackle the disguising of employment relationships through LLPs. And then the second bullet point isn't relevant. It made changes to the mixed members rules. And that's reflected in the response to the consultation document on page 665. Where again it's reflected, following the budget announcement, HMRC published on 20th of May a consultation, partnerships, a review of two aspects of the tax rules, consulting on how to change two aspects, partnership tax rules. The two main areas covered were the disguising of employment relationships through limited liability partnerships, LLPs. The same explanation was also included in the explanatory notes to the Finance Act 2014, which then introduced the salaried members' rules.
Well, I mean, if we're looking at the policy objectives as set out in the consultation document, don't we have to look at paragraphs 2.7 2.13 and 2.14.
Very happy to take you to that.
We may set out some detailed wording, but that gets jettisoned.
Yeah. So 2.7, the LLP is a unique entity as it combines limited liability for its members with the tax treatment of a traditional partnership. However, individual members of an LLP are taxed as if they are partners, even if their membership terms are such that the individual would normally be regarded as being an employer-employee relationship. For example, members will tax as partners even if they have fixed salaries, are not exposed to risk, take no substantive role in the management of the business and have no rights to profits or assets if the partnership ends. And 2.13. These conditions are not intended to apply to members who are in essence partners of a traditional partnership that is now carried on as an LLP. This means they are not intended to affect the status of members who carry on the partnership in common with a view to profit, who take risk in the business, and who are to a significant degree rewarded on the basis of a share in the profits. They are also not intended to affect the status of persons who are taken on as members at an appropriate point in their career in recognition of their professional knowledge and personal skills, and who sacrifice an entitlement to salary in exchange for the opportunity to participate in the business, in much the same way as a senior partner, even if, as junior partners, they are substantially rewarded by a fixed profit share. And then, my lord, you're entirely right. I was going to take you later to 2.14, but this is a very important paragraph as well. The overall approach of these conditions is intended to be similar, but not necessarily equivalent to the wide-ranging tests that would be applied in determining whether a person were a partner in a traditional partnership. Applying these tests to salaried partners and fixed share partners in traditional partnerships is not straightforward. It would be even harder to apply these tests to LLP members because the limits on their financial liability prevent the unlimited risk characteristic typical of traditional partners from being present. The proposed approach is a relatively simple approach for HMRC taxpayers and tax practitioners to use in order to determine whether a particular member is or is not to be treated as an employee.
Would you accept that that desideratum does indeed appear to have been carried through into condition B?
I would.
And that would suggest, would it not, that your starting point in most cases, well, in all cases, will be the LLP agreement, and in many cases that will be your ending point as well.
I would accept, we have always accepted, my lord, that the starting point is the LLP agreement, and I'll come on to develop these submissions further. We would say that taking a purposive approach, which I will be inviting your lordships to take in relation to construing condition B, we have to construe all of the words of the provision. And we start with the mutual rights and duties of the partnership, but we also have to give effect to what are the affairs of the business. And in order to analyse condition B, all of the words have to be given effect to.
Thank you.
And we say that it's important to keep this anti-avoidance purpose in mind, and to appreciate that the LLP structure was not adopted by this business in order to secure tax benefits. This LLP was a partnership which became an LLP. And it's important also to bear in mind that some 11% of its workforce are partners. We say, of course, it's necessary to construe the words used by Parliament with that purpose in mind and in the statutory context in which they appear. We submit that this applies as much to the reference to the mutual rights and duties of the partners as it does to any other wording. And as I indicated in my roadmap, I'll now come on to deal very briefly with the authorities on the approach to construction. I will be referring back to these in the course of my later submissions to the fundamental principles, and I am sure that the court is familiar with them, but I say they're so central to this appeal that I'd invite you to turn them up briefly at this stage. And there are only two authorities in the bundle that I would like to draw your attention to in respect of the purposive approach to statutory construction and aids to construction. So if we could turn first to Rossendale and Hertzwood, which starts in the authorities bundle. The authorities bundle, tab 38, page 487.
Yeah. You can take it we have read this before.
Thank you. Thank you, my lord. So I think I only don't need to take you to any of the facts. And I know my Lord Justice Henderson was in the Court of Appeal in this case in any event. But there was a dispute around the meaning of the word owner in the Local Government Finance Act. The judgment of Lord Briggs and Lord Leggett, with whom the other members of the Supreme Court agreed, starts at the bundle, page 497. And I'm aware, obviously, as you've indicated, my lord, that you're very familiar with this. But we can pick it up at page 499 from paragraph 10. There are numerous authoritative statements in modern case law which emphasise the central importance in interpreting any legislation of identifying its purpose. And then over the page at paragraph 13, after dealing with a number of the earlier cases on the very familiar Ramsey principle, you'll see the court approving the well-known statement in Arrowtown at the top of the bundle at page 501. That statement, the driving principle in the Ramsey line of cases, continues to involve a general rule of statutory construction and an unblinkered approach to the analysis of the facts. The ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. And at paragraph 14, the court continued, almost all statements of principle, however broadly framed, tend to be responsive to the particular facts under review. And towards the end of that paragraph, as Lord Nichols said in Westmoreland, the paramount question always is one of interpretation of the particular statutory provision and its application to the facts of the case. And you'll be very familiar in paragraph 15, my lords, with the two-stage approach that was then directed by the court to ascertain the class of facts intended to be affected by the charge or exemption. This is a process of interpretation of the statutory provision in light of its purpose. The second is to discover whether the relevant facts fall within that class, in the sense that they answer to the statutory description. The court went on at the end of paragraph 15, though, to say it's useful to distinguish these processes. There's no rigid demarcation between them, and an iterative approach may be required. Both interpretation and application share the need to avoid tunnel vision. The particular charging or exempting provision must be construed in the context of the whole statutory scheme within which it is contained. And paragraph 17, likewise, the facts must all be looked at in the round. And we submit this is what both the FTT did in this case and the approach that the Upper Tribunal upheld. I've referred you to the extra statutory materials that demonstrate that the intention of Parliament here was to prevent the disguising of employment relationships. And in our submission, this is the purpose that the FT and the Upper Tribunal clearly, from the terms of their decision, had in mind. So we submit there wasn't a construction error in the approach of either tribunal. And the FTT's findings of fact, as I shall submit, are clear. The other The other decision I'd like to take your lordships to briefly is Re O, and that is at the Authorities Bundle, tab 39. At page 520. And this is a decision of Lord Hodge, which I'm sure your lordships are very familiar with. The case was a judicial review and concerned whether regulations prescribing that registration fees payable in respect of children applying for registration as British citizens were ultra vires. But the relevant section that I'd like to draw your attention to starts at paragraph 28 on page 536. So picking it up at paragraph 29. The courts in conducting statutory interpretation are seeking the meaning of the words which Parliament used. More recently, Lord Nichols of Birkenhead stated, statutory interpretation is an exercise which requires the court to identify the meaning borne by the words in question in the particular context. Words and passages in a statute derive their meaning from their context. A phrase or passage must be read in the context of the section as a whole and in the wider context of a relevant group of sections. Other provisions in a statute and the statute as a whole may provide the relevant context. They are the words which Parliament has chosen to enact as an expression of the purpose of the legislation, and they are therefore the primary source by which meaning is ascertained. There is an important constitutional reason for having regard primarily to the statutory context. As Lord Nichols explained in Spath Home, citizens, with the assistance of their advisers, are intended to be able to understand parliamentary enactments, so they can regulate their conduct accordingly. They should be able to rely on what they read in an Act of Parliament. So he goes on in 30 to reflect that external notes to aids to interpretation therefore must play a secondary role. Explanatory notes may cast light on the meaning of a particular statutory provisions, but other sources, such as government white papers, may disclose the background to the statute and assist the court to identify not only the mischief which it addresses, but also the purpose of the legislation, thereby assisting a purposive interpretation of a particular statutory provision. The context disclosed by such materials is relevant to assist the court to ascertain the meaning of the statute, whether or not there is ambiguity and uncertainty, and indeed may reveal ambiguity or uncertainty. But none of these external aids displace the meanings conveyed by the words of a statute that, after consideration of that context, are clear and unambiguous, and which do not produce absurdity. So we say that the salaried members' rules aim to prevent the use of the LLP model to avoid employment taxes, in effect PAY obligations and employers' national insurance contributions. And to achieve this, Parliament enacted 3 specific conditions. As you've heard, the way the test works is that if a member of an LLP fails to meet, or colloquially simply fails, any one of those conditions, then Parliament has determined that that person should be continued to be taxed as a member of the LLP on the self-employed basis. So they pay income tax and national insurance, but are outside the PAYE and employers' NICS regimes. As my learned friend has trailed, condition B concerns the influence of members over the affairs of the LLP, and it's met, as we've discussed, if by reference to the mutual rights and duties of the members, a member does not have significant influence over the LLP's affairs. So if a member of an LLP fails condition B, if the mutual rights and duties give them significant influence over the affairs. And I'd note in passing, as our skeleton argument does, at paragraph 2b, that the words significant influence are undefined. As my learned friend has noted, I've trailed that I'll come on to condition A. Condition C will be met unless a member of an LLP buys in at a statutory percentage, but it's common ground that condition C is met by the members of the LLP in these cases. So on HMRC's construction, they issued several PAYE determinations and employers' NICS decisions on the basis, as my learned friend has submitted, that all but 4 members of the respondent met all 3 of the conditions and should be taxed as employees. And those 4 members who were excluded from the scope of the subsequent appeals were the original members of the LLP's Executive Committee, or ExCo. We submit, however, that it's clear from the purpose that the test Parliament had in mind was not a management or control test. And HMRC appear to be submitting that a management test is appropriate in these circumstances. We will say that there are other areas of tax law which, by contrast, do involve management and control tests. For example, the tax residence of company is where it is managed and controlled. And Parliament has specifically defined in both of the Corporation Taxes Act, the 2009 Act in section 472 and the 2010 Act in section 1124, a definition of control. And it's important to note here that the draftsman specifically did not import that into the salaried members' rules or otherwise use that term. So here what we are seeking to discern is influence and not management and control, which we submit as a different test. We say condition B further seeks to determine whether the members of an LLP can be influential in its affairs and not in its management, and therefore can apply irrespective of whether they are board members or not. And in essence, we submit that once the statutory words are understood, the test in condition B, as was held by the Upper Tribunal, is effectively a question of fact. And that's to be decided by looking at what are the affairs of any particular LLP, which is a question of fact. What is it that the various members of any particular LLP do pursuant to their mutual rights and duties, and whether or not what they do pursuant to their mutual rights and duties makes them significantly influential over the affairs of that LLP. And assuming it does, how and why the LLP members do what they do, that is, whether their mutual rights and duties to one another and to the LLP give rise to that influence. And this process of analysis leads, in our case, to 2 conclusions. First, we say the FTT found the right facts and applied the right law, as did the Upper Tribunal. And secondly, that the 2 categories of members, the portfolio members with capital allocations of 100 million or more, and the desk heads, did in fact have significant influence over its affairs.
Can I ask you this question? Would you accept that it would be an error of law for a tribunal considering condition B simply to ask itself whether the members in question had significant influence over the affairs of the partnership?
My Lord, depending on the terms of their decision, it might possibly be the case. What we say here is that the judge in the First Tier Tax Tribunal did consider the mutual rights and duties of the members. I'll come on to show you in more detail shortly. And in particular, the judge looked at and accepted that the mutual rights and duties were grounded in this LLP agreement. And in respect of that point, the relevance of the statutory reference to mutual rights and duties, I'd make the following 3 points. It was common ground between the parties before both the First Tier Tribunal and the Upper Tribunal that we are not confined to the written agreement. I think that most conveniently can be found in the First Tier Tribunal decision, if I can take it to you very briefly, or the Upper Tribunal decision at paragraph 114.
Once you move away from the
Apologies, my lord, my computer's just frozen. I'm just going to get paper.
once you move away from the contractual position, whether it's contained in the original LLP agreement or in some other contractual agreement, where do you stop?
I think it's a fact-sensitive test, my lord, and one has to look at the mutual rights and duties and what happens, as a matter of fact, with the partnership that you have in front of you. It's actually very difficult, I think, for us to extrapolate in other factual circumstances other than, say, the BlueCrest decision. In this particular case, you'll see the careful findings of fact of the First Tier Tribunal judge, where he went through what happened on the ground informally in respect to the mutual rights and duties. So we would say it stops there, as a matter of fact, in this particular case. But it's going to be very, very fact sensitive as to where you stop in respect of each particular decision and each particular LLP.
Well, I understand that, but can I ask you this question? What do you say are the legitimate sources of the mutual rights and obligations? Plainly, we've got the LLP agreement. If it's established that there is some oral variation or some collateral contract, no doubt, those would be sources of mutual rights and duties. Do you say that there are other possible sources of mutual rights and duties?
My lord, I would agree that they are all possible sources of mutual rights and duties. I would also say, in respect of this LLP, one has to look at the LLP agreement and see what the business of the LLP is. And I will take you to that shortly in clause 4 of the LLP agreement. And the business of this particular LLP was carried on, as the First Tier Tribunal judge clearly held as a matter of fact, on an informal basis, with all of the decisions being made by the partners in that informal manner, and with ratification in some but not all cases by the board. But that was the way that this partnership operated on the ground.
So does that mean that the way the business is carried on is a source of mutual rights and duties?
I would say it is in this case, when we look at the mutual rights and duties as expressed in the LLP agreement that we have in front of us.
And how is that going to be enforced?
My lord, I'm not quite sure what you mean by enforced.
Well, one ordinarily thinks as a right or a duty as something that is enforceable. And at the moment I'm wondering how, in your submission, the way a business is carried on informally gives rise to a right or a duty that can be enforced.
I think it's capable of enforcement because although it's an informal agreement between the members to operate the partnership in the way that was approved by found as a fact by the First Tier Tribunal, if that was not, if there were departures from that is still grounded in the mutual rights and duties agreed by the partners, even if that agreement is informal.
I'm struggling with the concept of an agreement which is both informal but enforceable.
My lord, I draw an analogy with an oral agreement, which would be enforceable in any event, even though it was oral.
Well, that's because it's a contract.
Yes. And this is effectively the agreement between the members on an informal basis how to run the partnership. I hope, my lord, that this will, when I take you to the definition of the business of the LLP, I'll be able to develop my argument further there.
And you'll take us to the FTT's findings
Yes.
of informal agreements.
Yes. My Lord, I just wanted to make 3 points, as I said, in relation to the mutual rights and duties, the statutory reference to mutual rights and duties. As I said, I'd just like to take you to the Upper Tribunal decision at paragraph at paragraph 114, which is at page 152 of the core bundle. And you'll see, my Lord, at 114, that the Upper Tribunal reflected it's correct to say that the focus of Condition B is on whether the mutual rights and duties of the members of the relevant partnership give an individual member significant influence over the affairs of the partnership. It was common ground in the present case that the judge was entitled to consider the actual position, and the inquiry was not restricted to the terms of the LLP agreement. And you'll see at 115, this position was recorded by the judge at paragraph 188. Both parties accept that significant influence does not need to be exercised through a formal constitutional procedure, but requires a realistic examination of the facts. In the context of this appellant, the investment and operational decisions made by the portfolio managers demonstrate they have influence over the affairs of the partnership, notwithstanding that the portfolio managers themselves may not sit on any of the UK committees.
That quotation reveals the problem, doesn't it? Because where in that do we have any reference to rights and duties at all?
Well, in 114, it's recognised that it's correct to say that the focus of
No, it's the quotation from the FTT in 115.
And as I will take,
it's simply asking the question: do these people have influence?
The missing middle in the logic.
And when I take you to the First Tier Tribunal decision, I think we'll see that, in particular, the judge did look at the LLP agreement, and therefore, on the basis of the submissions, was looking at the mutual rights and duties of the partnership as well.
Well, he certainly took it into account.
Yes.
But did he then go on to find that there were mutual rights and obligations arising out of something which happened after the LLP agreement was made?
I'm not sure.
I mean, all the Upper Tribunal say in 117, the Upper Tribunal says it's clear the LLP agreement was not ignored, but the evidence of what had happened on the ground in terms of who exercised significant influence proved decisive. So that's what he's saying, what the Upper Tribunal thought the FTT was doing was to concentrate on what was happening on the ground, even though the LLP agreement was, in their words, not ignored.
It wasn't ignored, and I think it was also, my Lord, because it was common ground between my learned friend and I in front of both tribunals, that we could look at the wider factual position. And so, at the end of the day, I think the tribunal was not directed necessarily by my learned friend to his, I think as he said, secondary position today, in relation to it all being grounded in the mutual rights and duties of the LLP agreement alone. I think, as he's indicated, that might give wider
or some
issues.
other source of rights and duties.
Or some other source of rights and duties. And we say what happened on the ground is a source of mutual rights and duties, because effectively it was the partners agreeing to conduct the business of the partnership on that informal basis.
Well, that's what you're going to have to make good.
Yes, and that's what I hope to. I just mentioned, in respect of, as I said, the statutory reference to mutual rights and duties, we would say that whether or not it was sort of an error in terms of litigation strategy for the HMRC not to focus on the mutual rights and duties in front of the First Tier Tribunal, we would say that that cannot now be an error of law for the FTT to decide this case on that basis. We would also say in our
Sorry, just
Sorry, if it's the wrong construction, it must be an error of law, mustn't it? I mean, it might be an inexcusable error of law, and indeed an understandable one. I mean, that's another question.
well, if I don't persuade you, my lord, that that there was no error of law at the end of the day, then I see the force of your point. I think my learned friend, as I said, has run the case in front of the First and Upper Tier Tribunals without reference to that. And indeed, there may be a point that I will come back to in relation to whether or not the hearing would have been conducted differently if that concession had not been made by HMRC, if we can call it a concession or position.
well, wait a minute. That if that's a good point, then that would preclude HMRC from arguing it procedurally. It's not a point you come back to. I mean, either it's a point you take now, and we have to decide it. If you're saying this is a new point, and if HMRC had presented its case differently below, the course of evidence would have been different. That's a different question. But it's not easy to see how, given that the FTT made the findings of fact on what happened on the ground, and the point that HMRC is really saying is, well, that's not relevant to the legal question that needs to be answered.
My lord, I think I will be instructed to make that submission. It was only today that we have had noticed that HMRC have changed their position in relation to this. I think as a response to my Lord Henderson's questions. So if I may be permitted, I think I might come back to that first thing tomorrow morning.
All right.
That of course makes sense, but can I just make this observation? At the moment, I'm struggling to see how there would be any objection, because the effect of the way it was argued below, it seems to me at the moment, was to allow in more evidence than would be permissible on the way that HMRC, by its secondary case, is now arguing it, rather than less.
I think there might have been a different emphasis in evidence, my lord. I think if we had understood that the mutual rights and duties were going to be the focus of HMRC's case, then we would have, I think, concentrated the witness evidence on the mutual rights and duties. I think we would have presented, we would, for example, have asked the witnesses who were called in relation to what are your mutual rights and duties and how are they reflected, because we might have had some evidence in relation to these informal understandings, for example, as to how the partnership was run as a matter of the business. So I think having not appreciated that HMRC were shifting their position in relation to this, I would just like to consider overnight whether or not there is a point to be made there.
Yes, well, if there is a point to be made, I think we would like to see some piece of paper which makes it,
yes,
as well
indeed, my
as
lord.
well as you're making it orally.
Yeah, indeed, my lord. Absolutely. The second point, just to make, following my learned friend's submissions this morning, it's our understanding that there isn't a requirement for LLP agreements to be in writing, and they don't need to be filed when the LLP is formed or at any time thereafter. And again, we will provide you with some case law to show that overnight. But that's
you can have an oral LLP agreement, can
yes,
you? And then you can orally vary it.
You can orally vary it.
Yeah.
And as you could, and I'll take your lordship's that in due course under the partnership.
Oh, certainly under partnership, but then you didn't have to register partnerships.
Exactly, but that's our understanding. And understandably, we will say many LLPs will be formed on an informal basis. And we'd say...
Well, I'm not sure about that. That sounds rather a startling proposition. I mean, you can't form a company by mistake, so how can you form an LLP by mistake? Or without realising what you're doing?
I think, not by mistake,
well, not quite by mistake, but even informally. I mean, it's inherently a formal matter, isn't it? I mean,
it is inherently a formal matter, as you'll see from the LLP agreement that we have here.
Yeah.
My understanding of LLP agreements in respect of this particular type of business, the alternative investment management industry, and my learned friend, being in a bit of danger of giving evidence, it is that these are relatively similar LLP agreements that are standard form with various amendments, but that they don't generally reflect They're not the hundreds of pages that would be necessary if one reflected all of the matters that govern the business on the ground and the affairs of the partnership. And I will come back to this, my lords, but I would just trail that even if HMRC are allowed to resile from the common ground that we've discussed, we say that the Upper Tribunal addressed these points in paragraph 117 of their judgment. It's at page 152 of the bundle. They say, though this is, in our view, sufficient to dispose of ground 5, the judge, in fact, considered the evidence in significant detail by reference to the LLP agreement and the position on the ground, and came to the conclusion that the portfolio managers each exercised significant influence over the affairs of BlueCrest. It's clear that the LLP agreement was not ignored, but the evidence of what has happened on the ground in terms of who exercised significant influence proved decisive in the decision of the judge in relation to portfolio managers. And they noted that the judge undertook the same exercise in respect of the non-portfolio managers and decided that they did meet condition B. As I've said, there is no express reference to mutual rights and duties, but that is, I think, a consequence of the way that the case was argued.
No express reference in the FTT decision.
In the FTT decision. And we also say that the Upper Tribunal recorded at paragraph 120 of their decision, and this is just over the page, at page 153, they accepted BlueCrest's submission that effectively the question in relation to condition B is a multifactorial test, which requires a careful analysis of all aspects of the workings of the relevant partnership.
That seems very strange. I thought you accepted earlier that we could derive from the consultation document this was supposed to be a simple test. And on the face of the statute, it is a simple test. I mean, surely this is getting away from the old multifactorial test that you have under traditional partnership. That was the whole problem.
I think there was certainly the problem of encapsulating the acceptive indicia of partnership into the three conditions, my lord. I think in asking what is significant influence and what types of influence are relevant for the purposes of condition B, that we would say is a multifactorial inquiry. One doesn't pick one type of influence, such as managerial influence, and ignore the other types of influence that may be relevant in each particular partnership. And we would say that the FTT approached this without being perverse or irrational in their approach to the facts. And the Upper Tribunal correctly recognised the application of the facts to the law is acutely fact-sensitive. But the question for this court is, of course, as my Lord Henderson has indicated, whether there was an error of law in that approach. So in summary, our position is the FTT and Upper Tribunal didn't make an error of law in their construction of Condition B. HMRC's challenge is founded on reading into the legislation words which run contrary to the legislation's natural meaning and its stated purpose. And the tribunals did have in mind the LLP agreement as the foundation for the relationship between the partners and the LLP, and they did give effect to the term mutual rights and duties. And in terms of whether those mutual rights and duties give the members significant influence, as we've seen, Hertzwood and Rio set out the applicable rules of construction to apply and the centrality of the words chosen by Parliament. And we say the appellant's appeal constitutes a challenge to the careful and detailed factual assessment that the FTT undertook and the Upper Tribunal endorsed. Alternatively, even adopting the proposition put forward by HMRC as their primary case, that the only relevant influence for condition B is managerial or strategic influence over the LLP's affairs, and applying that test to the unchallenged facts found by the FTT, we do say that the portfolio managers and the desk heads failed condition B in any event. And we say that was recognised clearly by the Upper Tribunal at paragraph 123 of its decision, and that's at the core bundle 153. You should still have open. The Upper Tribunal found.
At 153.
Yes, 153 still, my lord. Paragraph 123. At 194, the judge found on the evidence that the portfolio managers had demonstrated managerial clout. On HMRC's own case, this was significant influence that the statute required, and the very thing which the judge was supposed to be looking for. We cannot see how it can be said that the judge went wrong or misdirected himself, unless it was the case that the evidence did not exist to support this finding. And then the court went on to say there is a high threshold for a successful Edwards and Bairstow challenge. The difficulty for HMRC is that we were taken to a few selected extracts from the cross-examination. And we would say that our understanding of HMRC's grounds of appeal in this case was not that they were making Edwards and Bairstow challenges in front of this court. I'm not quite sure if my learned friend slightly departed from that at the end of his submissions, but we had understood that they were not making Edwards and Bairstow challenges in respect of this court. They weren't saying that the First Tier Tribunal were irrational.
Which is cited in a footnote to a skeleton argument.
Sorry, my lord, I didn't quite hear you.
Edwards and Bairstow is cited in a footnote to HMRC's skeleton argument.
Well, he may indeed be making Edwards and Bairstow challenges, but we hadn't understood that that was the case from his grounds of appeal. We would say he's not entitled to be making Edwards and Bairstow challenges in this court.
Well, there's surely a difference between an Edwards and Bairstow challenge as a kind of freestanding attack on a finding of fact which has been made and is said to be erroneous, and the question of what is the right consequential directions to give in the case where, assume we diagnose an error of law, what then happens? And I mean, the problem about inviting us to substitute our own decision here and now would be that the FTT, which is the sole tribunal of fact, simply hasn't had an opportunity to consider the position in the round in the light of the law correctly formulated. So in that situation, one strong instinct normally is to say remit it.
And I think, I'll come on to my...
Well, I suspect in the end that was almost what sort of sotto voce Mr. Vallet was inviting us to do.
I'm grateful, my lord. I'll come back to remit.
Okay.
It is our case that if the test is differently to be decided differently by your lordships, that it should be remitted, so that the First Tier Tribunal judge can decide on the basis of what you decide is the correct legal interpretation of Condition B.
Always assuming we're not overturned in due course on what the correct law is, of course.
So I'm coming on again very briefly as I've trailed, and as you've seen from my learned friends' submissions, to the background to the salaried members' rules, and in particular its grounding in the LLP Act in 2000. Partners in traditional partnerships, and since the introduction of the LLP Act in 2000, also members of an LLP are, as I've said, presumed to be self-employed. And in that context, what the salaried members' rules aim to address is, in my submission, an unintended mischief created by the Limited Liability Partnerships Act 2000. And in effect, it was too easy to be treated as self-employed by simply entering into an LLP deed, even if in fact your role was properly that of an employee and not a partner. And so, as we've seen, looking at the consultation documents, in order to preserve fairness and to prevent avoidance through LLPs just entering into an agreement, the statutory test was enacted to determine whether they should be treated as self-employed. And as I've said, and I've brought that paragraph to your Lordship's attention, in the consultation it's made clear that there was a deliberate choice made not to apply the common law test for partnerships to LLPs, as it was considered to be complex and uncertain. So the overall approach of the statutory conditions, we say, was intended to be similar but not equivalent to the wide-ranging tests that would be applied in determining whether a person were a partner in a traditional partnership. And this is because it was recognised that applying the old common law test for partnership to all the categories of partners, even in traditional partnerships, is not straightforward, and that it would be even harder to apply these tests to LLP members, not least because the limits on their financial liability prevent the unlimited risk characteristics that's typical of traditional partners from being present. And as you've trailed, my Lord Lewison, the consultative document explains that the salaried members' conditions were intended to be a relatively simple approach for everyone, HMRC, taxpayers and tax practitioners, to use in order to determine whether a particular member is or is not to be treated as an employee. I think, as my learned friend indicated, this may have been a triumph of hope over experience, bearing in mind that we are all here in the Court of Appeal.
Well, if that submission is right, that it was supposed to be relatively simple, that would militate against a rather granular examination of the facts on the ground, wouldn't it?
I think it's a result of the factual approach that needs to be taken to the wording, which is supposed to be relatively simple. I think it's a necessary consequence. I don't think
So the wording is simple, but the inquiry is not?
The wording is simple, but I think, in fact, the inquiry is not, my lord.
Well, then the simplicity of wording has not achieved its objective.
That may be the case, my lord. In any event, Parliament has enacted the three conditions that we've seen. And we submit it's perfectly permissible to look at the conditions through the lens of how they reflect the position of a traditional partner. But the traditional tests of partnership can take one no further than that in applying the statute. And that's how the FTT, we say, approached the construction of Condition B, and is the approach that the Upper Tribunal upheld. The fact, we say, that the PM members and desk heads are, as a matter of fact, significantly influential over the affairs of the LLP is unsurprising in my submission when the statute is construed in this manner. And that is because the BlueCrest's UK entity has always operated as a partnership in the same manner as it operated since becoming an LLP. And in those circumstances, its more senior portfolio managers and desk heads have always been its partners. And this is because they do carry out the affairs of the business. So in this particular case, we don't have the circumstance where employees have been dressed up as partners for tax purposes. It was an LP before it was an LLP, it was a traditional partnership, then an LP, and now a limited liability partnership.
So I meant to ask you earlier, are there actually any findings of fact about that succession in the nature of the business and the fact that this was just a continuation of the old one under a new structural form?
I think it's in the statement of agreed facts. And in the witness statement as applied by one of the witness statements, Cathy Kerridge's witness statement, as applied by the First Tier Tribunal, accepted by the First Tier Tribunal.
If perhaps overnight those
yes,
find you might be able to find a reference there.
Absolutely.
I'd be grateful. Thank you.
Of course, madam. Thank you. And indeed, as is set out in paragraph 13A of our skeleton argument, we would say the evidence before the FTT demonstrated that BlueCrest's rationale for converting to an LLP was the same as many other investment managers, to address the risk of unlimited liability that arose from using the historic limited partnership structure. It was not tax related. And indeed, my learned friend accepted before this court that the application of the 3 statutory conditions can't be replaced by a general inquiry as to whether or not the members of an LLP are in the same position as traditional partners. And that's always been BlueCrest's position. But we submit that HMRC's appeal, in effect, urges the court to depart from an objective assessment of the meaning which Parliament sought to convey in using the statutory words, including significant influence. And we've seen that the words chosen by Parliament should form the focus of the process of interpretation as set out in Re O. I've now reached section C of our skeleton argument and part 4 of my submissions, as I indicated in my roadmap. And
before we home in on condition B, would you accept that we have to look at the conditions as a whole?
I think we have to look at the condition B in the statutory context, which includes the other conditions
so
as well.
if you are a member of an LLP, you have no significant influence, but you are remunerated as a share of overall profits. You are taxed as self-employed, not as an employee.
Indeed.
And if you have no significant influence, but you have put some capital into the business, you are likewise taxed as a self-employed person and not as an employee.
In principle.
Yeah, I'm told there's some fearful calculation you've got to do.
There is some difficult calculation, and it's not entirely. Condition C, for example, is not entirely clear.
Yeah. So all I'm getting at is that condition B is not the be-all and end-all of how you are taxed.
There are 3 conditions, and you only need to fail one.
Each one of which must be met before you're taxed as an employee.
Indeed.
And that do you accept that's part of the context in which condition B has to be interpreted?
I do, yes, and that I think is evident from Rio. So as I've explained, BlueCrest submits the question of whether the portfolio managers and desk heads had significant influence. We say it's a question of fact, and we say that HMRC seek to interpret the statute by reference to their own gloss, rather than construing and applying the wording of the statute by reference to the facts as found by the FTT. And in our submission, HMRC's approach doesn't identify any error in the Upper Tribunal's conclusion that the FTT correctly applied the words of the statute to those facts. And I would note that the Upper Tribunal, as my lords are very well aware, has already considered and dismissed each of the bases on which HMRC put their case to this court. There's nothing new in this appeal that wasn't raised before the Upper Tribunal, other than my learned friend's second argument today, where he has moved away, I think, from his primary submission that you look at the facts on the ground, if it's necessary for your lordships to decide the case.
Just on that point, I had a thought. Could I ask you to have a look at the order for permission to appeal made by Lady Justice Falk, and we find it in the court bundle at page 127. And in giving her reasons, she says, 1, condition B needs to be interpreted in its context, which includes the other conditions, which is the point my Lord Justice Lewison was just putting to you when you accepted. 2, the test is not simply significant influence over the affairs without more. Rather, such influence must be determined with reference to the mutual rights and duties of members, which raises the question of how that reference affects the correct interpretation of significant influence. So I would suggest to you the point was flagged up in the grant of permission to appeal.
I think certainly the grant of permission to appeal flagged up the issue in relation to mutual rights and duties, but HMRC have always agreed that in looking at the mutual rights and duties, one starts with the LLP agreement, but that one is entitled to look at what happens on the ground, what happens as a matter of de facto factual circumstances. I think, my lord, that's the difference from the permission to appeal grounds that were set out by Lady Justice Falk.
Of course, it's always possible one should, in any event, have to look at what happens on the ground, because that might find a perfectly legitimate argument that there's been a contractual variation or something of that kind.
Indeed, and as I'm going to seek to show you, my lord, that in respect of this LLP agreement, what matters is what is the business, what are the affairs of this particular partnership. My learned friend contended that the Upper Tribunal erred in its construction of the word influence, additionally by failing to distinguish between employees who are characteristically subordinate and partners who are carrying out a joint venture. BlueCrest's principal response in respect of this submission is that subordination is not the test we need to construe and apply here. And we refer in our skeleton argument at paragraph 16a to the Upper Tribunal's decision dealing with this point at paragraphs 80 to 83 of its decision. That's at core bundle, tab 11-146. I don't think I need to take your lordships to it, but we say that the Upper Tribunal correctly applied, as it was bound to, the decision of the Supreme Court in Bates van Winklehoff, where Lady Hale observed in the context of a subordination argument that there can be no substitute for applying the words of the statute to the facts of the individual case. My learned friend, I think, maybe softened a little, might have been his wording in relation to his argument on subordination in his oral submissions. But that would be our answer to the subordination question. The appellants next seek to limit the word influence to mean only managerial or strategic influence. And I've already submitted that replacing the requirement of the statute to discern influence as a matter of fact with a legal test of management cannot be, in my submission, what was intended by Parliament.
Well, I think where he gets that from is what the influence must do. And he gets that from the combination, he says, of influence over the affairs of the partnership. And you, as I suggested actually to Mr. Black, you can't really chop up this sentence. You don't know what influence is until you've asked yourself influence over what.
Exactly, absolutely, and agreed, my lord. And this it is how we put it to the First Tier Tribunal, that we have to start with the affairs of the partnership. It can't be divided up. We have to look at what are the affairs of the partnership in answering the statutory question. So we have to start with understanding what the affairs of this partnership are, and then we look at whether the mutual rights and duties mean that significant influence is affected over those affairs.
Somebody might have great influence over what the director's wine cellar contains, but that's not necessarily the affairs of the partnership.
Rather less prosaically, I think my example was head of catering. I mean, rather prefer the wine cellar example, but no, agreed, my lord. So I've already submitted, as I've said, that we can't replace it with a legal test of management. And we say that HMRC are, in this respect, seeking to change the meaning of the words used by Parliament by effectively seeking to ignore the variety of ways that members demonstrate significant influence in the real world. And I was going to briefly refer you in this regard to South Yorkshire Transport Limited and the Monopolies and Mergers Commission, which is at the Authorities Bundle, tab 26, page 96 of the Authorities Bundle.
Are we going to get any more out of it than what you've quoted in your footnote?
No, my lord.
But I think I would still be helped by a quick glance at the relevant passage.
I'm grateful, my lord. I mean, this was a case concerning the meaning of the word substantial, very briefly, and the dispute arose in the context of the Fair Trading Act, which empowered the Secretary of State for Trade to refer monopolies to the Monopolies and Mergers Commission.
Do I see it's page 295 in the report 102 in the bundle?
It is, yes, it is. Authorities Bundle, tab 26, page 96. And the relevant statutory provision was whether the services were carried out in a substantial part of the UK. And the referral in point was a bus company merger that would have serviced 1.65% of the country. And the issue there was whether that was sufficiently substantial to permit a referral. And in looking at the meaning of the word substantial, the judgment at page 102 of the bundle, between B and C, the very short point that we referred to, just before C, the courts have repeatedly warned against the dangers of taking an inherently imprecise word and by redefining it, thrusting on it a spurious degree of precision. And we would say similarly, and I don't...
So would you accept this paraphrase? Substantial means substantial, and substantiality is to be judged by reference to the objectives of the Act.
I would agree with that. I would agree with that.
And likewise here, significant means significant, and significance is to be judged by reference to the objectives of the Act.
Absolutely, with its purpose in mind. And just to finish this point, similarly in MacDonald and Dexter, and I don't need to take you to that, it's a case about an employee benefit trust where HMRC had disallowed a corporation tax deduction, and that concerned the statutory definition of emoluments. And in that case, all I need, and I can give you for your note at Authorities Bundle, tab 28, page 126, is Lord Justice Jonathan Parker's caution against substituting a gloss for the statutory words and thereby attempting, in effect, to rewrite the statute.
You finish off this point now, Miss?
I have finished that point, yes.
All right. Well, will that be a convenient moment to
It would be a
break?
very convenient moment.
How are we doing for time?
Well, I think I'm doing well. I think in relation to time, I think I'm going to finish comfortably tomorrow morning in order to give enough time to both my learned friend and myself to reply.
Right. All right. 10:30 tomorrow.
All right.